Well, good morning, everybody. I'm Jonathan Zittrain, HLS's Vice Dean for Library and Information Services or Resources, depending which part of the website you consult. Here with the stirring peroration to tell you this is being live streamed, recorded, and photographed for various platforms, including, I guess, various security services and possibly Ocean's 11. So just be aware that we are surveilled at all times, that is all. Something for which Magna Carta might be relevant. If you have any questions, need water or restrooms, the lobby is your friend. There's a library liaison that can help steer you there. And also, I believe we may have, for those in person, a few opportunities still for viewings today of the real Magna Carta. So you can talk to the ambassador about that. Before we get our own second panel of the day started with our experts, we are privileged to hear from Dean John Goldberg. John just came back from Sicily. I'd like to think specifically for this panel, but I think you're back generally. And it's just wonderful. John has helped steer our institution through an unprecedented, tumultuous time. And I don't know about you, John, but being able to think more longitudinally about the big picture is very much welcome all around. John, I am so pleased and privileged to be your colleague. Thank you so much for being here today.
Welcome, everybody. I am John Goldberg, the interim dean of the law school, and I am truly delighted to be here to celebrate the identification in our library's collection of a document of unique significance to Anglo-American law, an original Magna Carta issued in 1300 during the reign of Edward I. That's amazing. Let me begin by welcoming Professor David Carpenter of King's College London and Professor Nicholas Vincent of the University of East Anglia. It is thanks to their encyclopedic knowledge and discerning eyes that we are gathered here today. We are so grateful to the two of you for having identified this treasure in our midst. I am equally grateful to my wonderful colleagues, Professor Charlie Donahue and Professor Elizabeth Kamali, for bringing to bear their own expertise in medieval English law while working closely with Professors Carpenter and Vincent to bring us to this very special moment. Magna Carta might be described as memorializing and effecting an irrevocable grant of basic liberties and rights by the English monarch to a group of rebellious barons. This is why one finds within it mention of scutage. Did I pronounce that correctly? Scutage, which I gather was money paid by a vassal to a lord in lieu of military service. But at least since Edward Coke invoked the Great Charter as a counter to the pretensions of the Stuarts to absolute monarchy, it has been understood to stand for broader and deeper principles. Famously, Article 29 insists that, quote, no free man, today we would say no person, shall, quote, be taken or imprisoned nor dispossessed of his free tenement, nor of his liberties or free customs, nor outlawed, nor exiled, nor in any way brought to destruction. Nor shall we go upon him nor condemn him except through the lawful judgment of his peers or through the law of the land, unquote. It adds, quote, we will not sell to anyone, nor will we not deny nor delay to anyone either right or justice, unquote. Here in the United States in 2025, we stand on the eve of the 250th anniversary of our nation's founding. As John Philip Reed and others have demonstrated, there was a certain irony in the American case for independence, which rested first and foremost on claims about the colonists' legal rights as Englishmen, including the rights traceable to Magna Carta. The rediscovery of this critical early attestation to core Anglo-American political commitments, to liberty, to limited government, and to the rule of law, thus happily gives us occasion to recognize and reaffirm the shared values that continue to bind our two nations more than 800 years after Runnymede. Let me conclude by taking this moment to acknowledge the extraordinary work of Harvard Law School's librarians, without whose painstaking efforts to acquire, preserve, curate, digitize, and make available the incredible resources of this remarkable repository, we would not be here today. Special thanks and congratulations are owed to our Vice Dean for Library and Information Services, Professor Jonathan Zittrain, who you just heard from, and our Assistant Dean for Library and Information Services, Amanda Watson. Under their leadership, the Harvard Law Library has made and will continue to do what libraries are meant to do, to make knowledge available to scholars and to the world. Thanks to you and everyone involved with running our library for making this very special moment possible. With that, I turn things over to Professor Zittrain. Thank you.
Thank you so much, Dean Goldberg, for setting the stage. I was expecting some extemporaneous remarks, and instead that was fascinating. Thank you. And there's more where that came from with a panel this distinguished and expert. Getting even more ancient, perhaps, than medieval times, I think of the Greeks, ethos, logos, pathos. So starting with ethos, I'm just curious, by way of introduction, Professor Carpenter, when did you know that Magna Carta was going to be a huge part of your life's work, that you would be writing, if not the, possibly the, a definitive work about Magna Carta?
It's terrible. It goes back a tremendous long way, and to a work which is no longer looked at, I think, but it's called Bishop Stubbs's Select Charters Illustrative of English Constitutional History.
I saw the movie.
Yeah. Yeah. And I did this as an undergraduate, and I went through Magna Carta, then chapter by chapter, clause by clause, studying it. I don't know whether you did this too, Nick, or you're too young to have actually, it had been abolished, I think, by the time you did your degree. So it really goes back, I'm afraid to say, that I did my degree in the late 1960s. So
and you were reading clause by clause of the Magna Carta, right. And each one you were like, yeah, this is it.
I think actually that also raises a wider issue, which is worth thinking about today, which is that Magna Carta is famous for asserting the rule of law, and we've heard the most famous chapter quoted very eloquently, if I might say. But I think it's important to realise, and this is something of contemporary relevance, that it's not just asserting the rule of law in a series of high-sounding platitudes. It's doing it in a very nitty-gritty way across the whole range of royal government. Justice, finance, local administration. And equally, I think it's important to realise that although Magna Carta has, in a way, a black reputation as just being a selfish baronial document, it wasn't that. Even in the start, it reached out to wide constituency. It reached out to the church, to towns, to knights, to free men. I mean, the famous clause you quoted, no free man. Admittedly, that leaves out, most of you here would be unfree peasants. It's true in 1215, but nonetheless, it reaches out to wide sections of society. I think that's very important, the detail of the Charter in regulating what the ruler can do.
And just before turning to Professor Vincent's introduction then, and following that thread, you've both mentioned Clause 39 and 39, I think.
It's 29 in the in our charter here, in 39 in 1215.
So we're all right. That's very good. I like that a lot. Yeah. And that is then, as you say, part of a really comprehensive framework from the sublime to the something other than sublime. I look at clauses like, well, gosh, now I'm a little gun-shy about my clause numbers, but 33, all fish weirs are in future to be entirely removed from the Thames and the Medway and throughout the whole of England, except on the seacoast.
Well, I've got a story about that, because in 2015, Nicholas and I went out to China, and to actually have a conference at Peking University about Magna Carta. And it's been put on as an act of reform. By the time we got there, all reform had been ended. And so all these poor Chinese academics had all been told to give talks about the most meaningless chapters in the Charter, which had no wider significance. And the favourite one was fish weirs in the Thames, which is completely safe. And they worked out the hypothesis as this got rid of salmon in the Thames. So
but this is like a decoy provision. This is sort of the safe...
It was certainly used as a decoy provision by the Chinese academics. You were there too.
Except, David, of course, it is actually freedom of navigation, which is a rather important principle. So even behind what looks like total anachronism, you can actually find something of relevance today. I mean, Magna Carta's got stuff about free trade.
Yeah, no tariffs.
No tariffs. I mean, not that these are in any way current debates, but...
Nick, that's a great prompt to just complete your introduction. How did you get into this zone, and when did you realize this was going to be such an important area of your work?
Well, I really started... I've edited a lot of royal charters. And when the...
you mean annotated?
I've edited, I've collected and edited the charters.
I just thought edited might mean root access, where you're rewriting the charter.
No, well, perhaps I've done that too, but you'd have to dig very deep to find the evil there. But no, I was editing the charters of the Plantagenet Kings of England, collecting them and publishing them. And then the Magna Carta that belonged to Ross Perot came up for sale in New York. And I was called in to act as special advisor to that. And what really became clear there, pretty much immediately, and David and I had already, in a sense, picked up on that, was that since William Blackstone in the 1750s, no one had really worked on the textual, the material side of the Charter. How many originals were there? Where are they? How many were in the UK? How many elsewhere? Were there new ones to be found? So it's really that brought me in. And the realization that people had taken it for granted that because this document is so well known, everything about it must have been recorded back in Blackstone's time. Whereas the reality, as we can see with the document here, is very different.
And then just a really basic question to level set for everybody. What makes an original an original?
Well, I suppose that it's issued under the King's seal, and it is one of those documents that was sent out officially by, in this case, by Edward I, or earlier by Henry III, or earlier by King John. And the comparison I was drawing yesterday is a bit like the Yellow Pages. I believe you have the Yellow Pages in the States, this directory of telephone numbers. When you get the next one, you throw the old one away. So with Magna Carta, although King John's Magna Carta is, as it were, the most famous of these originals, that lasted in law for less than 12 weeks. And then you get the renewals by Henry III, and then eventually the renewals by Edward I. And what you've got here is the most up-to-date version of Magna Carta Yellow Pages.
Yeah, I just reiterate that. I mean, there's clearly a difference between the original, which is set out by the king, and it's written by his scribes and so on. Once you've got an original, anyone can copy it. And Harvard Law School, in its collection of statute books, has got huge numbers of copies made of all the various versions of Magna Carta, but they have no validity other than as a testament to the original document set out. I mean, just to reiterate, you've got the best, 1300 is the best final Magna Carta. It's far better than 1297. It's better than all the previous versions because it's got 2 lots of witness lists. In other words, twice in the 1300 Magna Carta, all the great and good of the land have come together to agree it. So that you've got the 1225 witness list, because Edward is saying, look, I've inspected the charter of my father, here it is, and here's its witnesses, 1225. And then you've got the 1300 witness list too, in which everyone, all the great nobles of 1300 come together and witness it too. So 1300 is the final, definitive, authoritative Magna Carta, and it's what is on the statute book of the United Kingdom. So Harvard Law School has got the best.
Well, we could end the panel right here and just quit while we're ahead. But there was some allusion to a retraction anything you want to say about a retraction in the intervening years? Did King John, maybe it was after the 12 weeks, have a change of heart?
Well, I don't think John ever... He didn't change his heart, which remained black throughout. He didn't change his mind at all. You realize, of course, that if you agree to something under compulsion, you are not necessarily bound by that. So the argument here, very clearly, is that John had been forced into this settlement by the threat of violence, rather like a marriage forced through violence, and therefore he was able to appeal to the Pope. So by the end of August 1215, the Charter's dead in the water, the Pope had annulled it. And it's the renewal of that document later on, now as a manifesto of good government by John's son, that, as it were, sets it on the road to constitutional normality.
And was less coerced down the line.
I mean, the absolutely key thing is that the 1225 Charter is a consensual document. It's issued by the king in return for a tax. So that gets rid of any idea that this is a product of coercion. And then Edward I in 1297, and best of all in 1300, then confirms the 1300 Charter. So it's twice over. It's a product of a consensual, all the great and good of the realm coming together. So that wipes out any, and although it begins in 1215, as an act of coercion. The subsequent editions come in 1300. No one can argue that anymore.
Fantastic. So we should turn to our local colleagues. Thank you, Professors Kamali and Donahue, for being here today. And curious the extent to which, in your work, how large does this particular thread loom in the mosaic?
This particular thread meaning the specific...
All things Magna Carta.
All things Magna Carta. Well, certainly, both when Professor Donahue and when I teach English legal history, I think we both devote a lecture to the topic of Magna Carta. But to be honest, in my own scholarship, and my students of criminal law know this, I often like to say, well, what's the important thing when we think about the history of criminal law, that happened in 1215, to get them to be like, Magna Carta. And I'm like, no, the Fourth Lateran Council.
Of course,
yes,
trick question.
In terms of when England switched to the use of jury trial in felony cases anyhow. So Magna Carta does loom large in our teaching. And Charlie certainly can say more about in his teaching, but also in the displays of manuscripts that we put out for our students as part of that experience of learning about English legal history. Historically, I have not put out HLS manuscript 172 in the items on display with the help of K.B. Beck originally, and more recently with Sarah Wharton. But I put out, for instance, HLS manuscript 175, which is a Magna Carta cum statutis, where you see Magna Carta as the featured first item in that collection of statutes, and then you have the succession of largely 13th century statutes following upon it. For students to see books of that kind, things like registers of writs, the books of practitioners that kind of give students a keen sense of the material culture of what the practice of law looked like, the equivalent of Westlaw and Lexis, I guess, for students today.
But cheaper.
Cheaper. Well, I suppose it depends if you're comparing the value of one of those registers of writs and a Westlaw subscription today.
Yes, fair enough.
It might be a little bit more of an even
Constitution
plane.
as a service.
Yeah.
Sorry. Charlie.
So basically the same as Liz in terms of how I use it in my teaching. I've also written a little bit about Magna Carta because everybody who knew anything about English legal history, even if they knew nothing at all about Magna Carta, was asked to write something at the time of the anniversary. And so the two things that I wrote was, the first one was Stubbs's statement that all of English constitutional history is but a commentary on this charter. I decided that was not quite right. And
the Mississippi State debate team is listening very carefully for their debate later this day. Yes.
And the other one was about Magna Carta in the 14th century. And one of the things that I found quite interesting was that in addition to the very specific provisions in the Charter that were current law at the time and remain so for a very long time, such as the separation from King's Bench and Common Pleas, there also came to be in the 14th century, but not before, every time the king wanted money, the first thing that the Parliament asked for was a confirmation of Magna Carta. Now, why they asked for that, I have absolutely no idea. But clearly what was happening here is that the thing was becoming symbolic, even though it was also real law in terms of a lot of its specificity. And when the specific didn't work, Parliament would get rid of it. I mean, the English law no longer has the provision about fish weirs in it. So, enough said.
There's the maxim that there's nothing so powerful as an idea whose time has come. How universal or suffusing then or in the periods you were talking about after are the ideals within something like Magna Carta? Were there other, as we would call them dryly today, jurisdictions where the same percolation was happening? Was this highly specific to the Anglo domain in that time? How much was this something that crossed cultural, political, jurisdictional boundaries?
Are we going back to...
Liz, I think, is going to take a crack at it.
I mean, I will just very briefly say, and I will look to our Magna Carta experts to elaborate. I think Magna Carta, in a way, is part of a much broader movement in Western Europe towards the articulation of rights and liberties and the articulation of limitations on the power of monarchs. So you have things like the Golden Bull in Hungary, which similarly sets out, again, with a focus mostly on the nobility. I don't know that it uses the language of a free man, even to be as broad as Magna Carta in that sense. And then, I think there are broader ideas in circulation. People like John of Salisbury, who at some point is secretary to the Archbishop of Canterbury, who in his Polycraticus and in other writings talks about the king being under the law, being subject to the law, and even being bold enough to talk about what one does when faced with a tyrant. And that, is in the 12th century that John of Salisbury is writing. So these are ideas that I think are partly coming out of the Catholic tradition. I think they're partly coming out of the rediscovery of Roman law. But they are ideas that have, I think, a broader influence, and Magna Carta is an instantiation of that, but one which I think has had the biggest effect worldwide over centuries.
Got it. Anything to add?
Well, we were down in the vaults yesterday. We were taken by Amanda down into the amazing vaults of the library. And I remember seeing there a huge volume of Spanish jurisprudence. And of course, in the 12th and 13th century, some of the Spanish constitutions, legislative constitutions, very much echoed Magna Carta, and you've written about that, Nicholas.
I mean, Spain or Sicily or Germany or, as Liz said, Hungary, it's all part and parcel of the same spirit. And the necessity of having the law written down. You can't go, really, in the 12th century anywhere and find a written law. What are the laws of the land? And this is one of the arguments against tyrants. Why are tyrants what they are? Well, they do not observe the law. They do not allow the law actually to be read. And they ignore accepted custom. And again, it's extraordinary how current some of those debates can seem.
Could I just add to that, actually, which is that in 2015, I also went to St. Petersburg and gave a talk. There was a conference about Magna Carta there with Russian lawyers, and they said that all these good things in the Constitution set up on the fall of the Soviet Union. Trouble was, nobody knew what was in the Constitution, and it was overridden all the time. And I thought, what a contrast to Magna Carta, because Magna Carta, and this is where the statute books here of this magnificent collection of Harvard Law School statute books show, it was copied again and again and again in the 13th century and beyond. It was studied intensively. People knew the differences between the various editions and versions. And I think that's how it sunk such deep roots into the English polity from whence it ultimately went round the world. So I think that's something to remember today too, that it's vital to actually know what is in your constitution, because unless you know what's there, you can't even begin to think of how it might be enforced.
You mentioned copies and copies and copies, and of course attested ones so that any changes are intentional and understood by everybody. And we have in our display, a bit of sponsored Yellow Pages advertising, our display in the Kasperson Treasure Room, a number of versions of copies of Magna Carta, including pocket editions for ready reference, maybe for just these instances. I'm curious then, now that we know that HLS manuscript 172 is an original, what, maybe from our parochial view as a university, what's different?
Well, I think it's very, very evocative and powerful. I mean, although one can look at all your lovely copies in the statute book, I don't think any of them have got the emotive power or the authority of an actual original, because they all derive from the original. Without the original, there would be none of the copies. So now you've got an original from which a copy is made. I mean, one thing worth going through your statute books to find how many copies are actually made of the 1300 one. I suspect large numbers are, because that was the final authoritative version. So I think in terms of emotive power now and authority then, there is no substitute for having an original.
And you are also, you're one of 3 institutions outside the UK that now have an original. And there was talk earlier on about the rather tatty state of your original. But believe me, it's far less tatty than various others that I've seen.
We'll take it.
And then we talked earlier on about provenance. The provenance of yours is simply extraordinary. And I know that Peter Maynard is listening in, I think, today.
Explain who he is.
Well, see when we trace where this charter came from, it was sold in London in 1945 at the end of the war. It was miscatalogued, and that's why it was misdated and so on. But we found out who'd sold it, and it was an Air Vice Marshal, Maynard. How on earth had an Air Vice Marshal come into possession of the charter? Well, eventually, and really via a series of accidents, we were able to trace the family. Well, it's Christopher Whittick, but we did eventually find the grandson. And initially I couldn't get a telephone number for him, so I sent him a letter, but I put the wrong sort of stamp on the letter. So he had to go to the post office and pay to collect.
That was very clever, what you did.
Which was really to add insult to injury, because I then had to explain to him that his grandfather had sold for 42 English pounds, something that was worth rather a lot more now. And his immediate reaction, apart from laughing, he has a very rich sense of humour, and would need it in their circumstances, but he said immediately, Clarkson. And the likelihood, we can't prove this, but the likelihood is that the charter came to the Maynard family, to the Air Vice Marshal, who himself was a defender of liberty. He was the air commander on the island of Malta at the beginning of the Second World War, defending the island against attack. But it came to the Maynards from the Clarkson family. Now, the Clarksons are one of those originators of the abolitionist cause in England, Thomas and John Clarkson, who between them recruited William Wilberforce to the cause of anti-slavery. Thomas Clarkson ended his career meeting Frederick Douglass and carrying the torch of abolitionism over to the United States. So we've got a document that belonged to one of the key figures in the anti-slavery campaign, that then belonged to a man who defended Malta against the powers of fascism in the Second World War. What better provenance could you possibly invent? Indeed, it is so good that I do wonder sometimes whether we did invent it.
It's also a great window into how authentication of this sort is done. The last panel talked about things within the four corners of the document, scans and assessments of the words, but the other is the provenance and seeing if it connects up to a chain from one of the originals. If it's okay, I'd love to dub this temporarily a committee for the highest and best disposition of Harvard Law School's Magna Carta, and solicit advice, aware from the last panel of some of the challenges of taking something that may be now that much more precious and valuable. How would we display, the temptation is, all right, now that we've got it, it should be in an undisclosed location forever. I guess in case we need to reboot society, we can pull it out. But what should the university do with it? And whatever you'd like to say on the subject, I don't know, Charlie, if you have thoughts to start with.
I do, but so let me pour a little bit of cold water on the party for just a second. We have things in our special collections because of their scholarly value. This has no scholarly value. I mean, absolutely everything in it is totally known. There's nothing to be discovered out of this document.
I love how you describe this as a little cold water.
So the second step, we have things in our collection simply in order to show them to our students. We have Oliver Wendell Holmes' lunch pail. I assure you that has no scholarly value. But, you know, it's kind of fun to show
just to assure everybody, we did clean it out. Sorry.
But we can't display something that's worth that much to our students here because we haven't got the capability of doing it. We haven't got the physical setup, we haven't got the guards, we haven't got the, okay. So that's why I asked the question of the people from Houghton. Do they? And I'm not sure they do either. So shouldn't this be some place where a lot more people would be able to see it? In which case, does that suggest that maybe we ought to get rid of it? In turn for some compensation.
Liz, did you want to offer a thought before we shift to our guests?
So, you know, Charlie had raised this idea in an earlier conversation, and once I got over the shock and horror, I then thought, like, how many new, like, manor court rolls could we buy, you know, with the equivalent of this? So, I mean, there is that thought, and also just the thought of libraries being under great financial constraint at the present moment. Of course, there are other solutions to that, like trying to get more alumni donations and so forth in the interim. It does seem as though there is tremendous value in the original in the sense of the way in which, so the first panel described David and Nicholas, you know, going into the room and seeing for the first time in person their 1300 original and the powerful experience of that. And I think for any of you who have traveled to the National Archives and been able to, you know, see original documents there, or have gone to the British Library and so forth, that experience of seeing the original can be very meaningful, very powerful. And so to the extent that this, I'm pointing to the facsimile, but the original has that potential to offer a really meaningful experience to the broader public, then you know, there's the question of, do we sell it elsewhere, or do we put it on long-term loan in the way that the copy in DC is on long-term loan? I think
from a private buyer,
buyer,
then want
it
to see
on,
it displayed in the public
I think
interest.
a permanent loan
Yep.
to the National Archives. So, I mean, then there's the thought, well, the West Coast doesn't have a Magna Carta. Ought they have one? My thought, I mean, was also just, Massachusetts being sort of the cradle of American liberty, this also seems like a special place for, having some way of displaying in a public sense the actual original. So clearly I have like wide-ranging thoughts, and I'm not quite sure where I would land if I had to give advice.
Uh-huh.
If I may put the thing a little bit back on the boiler, from the cold water to the rather warmer water.
I knew we were going to get a tea metaphor before long.
You have a unique instantation, I think was the word used earlier on. You have something utterly unique here. And yes, it's true that the text adds nothing, and it isn't a very beautiful document. I remember when we displayed the John Charters for the anniversary in 2015, I watched the first lot of people go around the old exhibition, and they got to the end, and there's the original Magna Carta, and one lady said, "Is that it?" That is it. But it's encrusted with so many layers of significance, where it came from, where it's been, and that it's now here. And you have so many other things here, apart from the lunchbox. You've got the Declaration of Independence. You've got the original amendments to the Constitution. You've got documents that throw light on the circumstances in which Magna Carta was made and reissued. So I think there is an opportunity there really to display a beacon of liberty, always bearing in mind that freedom, the cost of freedom is eternal vigilance. And vigilance and display go hand in hand.
Well, no, I couldn't agree with that more. I mean, it would be wonderful if some great donor or maybe some crowdfunding could have a sort of rule of law gallery here. I mean, you already got the origins, a part of it, in the wonderful exhibition upstairs, which was done for 2015 and which has been amended now. So you've got a huge amount of wonderful material there already. But you could, as Nicholas said, you could link it on to the Bill of Rights and everything like that, and documents connected with the foundation of America on into our own time. And I do think the emotional power of seeing, I so agree, seeing the original documents is very great. It's inspirational. And I think we need inspiration now in the defense of the rule of law. And nothing would be more appropriate for Harvard Law School somehow to get the funds to have a permanent display, a permanent exhibition in which obviously your wonderful 1300 Magna Carta would play a part.
May I say one
Yes,
other
please.
thing? There's always a risk also of the commodification or the commercialization of something that is the very opposite of that. And all of this talk about security guards and so forth, yes, there are a series of very strange people who have recently tried to attack Magna Carta in the British Library at Salisbury. But in various places, Magna Carta's exhibited in the UK with the minimum of security. The one I found in Sandwich is looked after by a former sergeant major in the British Army, and it's on public display. And that's one of the real problems I think, in our present day, is trust. Is to trust people that they will actually respect certain things. They will respect the rule of law. They will respect the objects that they come to see in a museum with a certain amount of care. You know, a bit of plexiglass never did anybody any harm. A bit of bulletproof protection. But I don't think we're necessarily talking here about a massive amount of money to put this on display.
Why don't we open it up to questions from the audience? We have microphones so that they can be on the live stream if needed. Thoughts, questions, whether on form or on the substance? We have someone right here. Let's get a microphone over to you. And by all means, feel free to introduce yourself.
So yeah, I'm David Sipe. I taught at Boston University. have a tiny little story about the talismanic significance of a reissue of Magna Carta. I'm very low on the list of medieval legal historians, and so it was not until October of 2015 that I was asked to give a talk, and it was to the 3 Hong Kong law schools. And just before then, a reissue, maybe you followed this, a reissue of Magna Carta was circulating from the British government in Beijing and Shanghai and Guangzhou, intended for large audiences to view, but then shrunk to very short availability in the consul residence for each city because of the, again, I said talismanic significance of Magna Carta and the fear that crowds would flock to this thing as a symbol of something. I was about to give a talk on Magna Carta at the 3 Hong Kong law schools at a joint event, and I asked them when I got there, is the Beijing government going to allow this this talk? They laughed and said nothing said in any academic conferences of any interest to the Beijing government, but the young scholars in Hong Kong were very, very powerfully evoking Magna Carta in its symbolism as opposition to overweening government authority and giving much more powerful remarks than I made. But I just want to reflect that that additional
this is what we felt when we were in Beijing, and it was a really sad time because the conference had been put on. We were told by the old Chinese hand, a specialist, by a professor who'd been quite close to the Chinese foreign minister. And by the time we got there, the foreign minister was out and the clampdown was beginning. And it was terribly sad because I think the majority of the Chinese academics there were scared, weren't they? Scared about what they said and so on.
Except there were also, as David says, there were young people there who did actually speak very movingly and very eloquently.
Yeah. And then they were shut up, weren't they?
They were indeed shut up, very, very firmly. Our understanding, I think, was that the Chinese government believed that Magna Carta was something a bit like Tutti Frutti, that they didn't really understand quite what it was that they'd invited over, except that it was very old.
And then when they did understand, their attitude completely changed.
But that in itself is interesting, of course, because Magna Carta isn't a document necessarily of either left or right or tradition or radicalism. It appeals to all constituencies. It's been used by the radical left. It's used by the extreme capitalist right. So it is an extraordinarily polyvalent document, which is one of the reasons that it keeps cropping up in debate. So, yeah, I mean, I think that tour of Magna Carta was interesting.
Well, when you say polyvalent and thinking about 700 or 800 years removed from it, how much is any contemporary application to see what light it sheds on current events, on trends? How much of it is what we're bringing to it from here, the present, versus, if at all, what could be identified with full context as truly salient in its time?
Well, actually, I mean, I don't quite agree with Nicholas there. I mean, I think that some of the basic principles of Magna Carta, the famous clause you read out, are as redolent and significant then, and in the same way redolent and significant as they are now. I mean, the fundamentals are no one is to be denied right or justice, that justice is not to be sold, that the ruler can't act against you save by due process of law. I think these are fundamental principles which resonate down the ages. And,
I don't disagree with that, David, but my argument is that it's used by all sorts of people in all sorts of ways.
But I think we are entitled to say it is sometimes wrongly used.
Yes.
I have a question. Can I ask?
Just before you ask, Charlie.
I cannot resist. There was a woman who was a real specialist on the use of military force within the United States who was talking on National Public Radio. And all that she said was absolutely right. She had all the statutes. She had the constitutional implications. And then at the very end she said, and the principle that you do not use the military instead of the police goes back to Magna Carta.
Yeah.
It does not, because there were no police.
It was in there, though. It was latent in the space, as we say.
Sorry.
Yes, feel free to
So I have a
introduce yourself.
question about the witness list. And so one is I was curious where in the document it is, if it's on the bottom. But also I was wondering how you use the witness list in your study of the different versions, and is that partly how you assess when it? Well, I'm curious on the body of people who signed it and the meaning of the different people and how you interpret that.
I mean, that's one area in which the 1300 Magna Carta is the finest and the most unique, because it has two witness lists. It's got the witness list from 1225 and the witness list from 1300, and it essentially does reflect who the good and the great of the land were then. And probably it is those people gathered together in Parliament. I mean, 1225, there is no Parliament by name, but the body is there. By 1300, it's the parliamentary peerage, in a sense, who've come to authenticate and witness the issue of this document. And yeah, I mean, it would be I don't think actually there has been a detailed simply an assessment of who all these people are, although it wouldn't be very difficult to do. In fact, I'm giving a talk in October about the 1225 witness list, and people are particularly keen as to see where the various monasteries rank, because the whole load of abbots are listed there. So I'm giving a talk about that. But so, yeah, I mean, I think the witness list is hugely important in showing that the consensual nature of Magna Carta, and the 1300 one shows that twice over.
How long did it take, by the way, to draw up the document in that era?
We neither of us are mad enough to have copied it out in medieval script, but we reckon it was many hours, 5, 6, 7 hours, something like that. We have asked paleographers roughly how long it would take. So that's the day's work for a scribe, and it has to be absolutely perfectly copied. So including the names of the witnesses, which do occasionally get jumbled. But I take David's point entirely that the witnesses really are very important. They are the founding fathers in the same way that your Constitution and your Declaration of Independence have a group of people who are intimately associated with that. And I think it's worth saying also that David and I both really came to Magna Carta. Yeah, we knew the text, but we came through an interest in the people around the court of King John and Henry III. So these are to us as important as Jefferson and Washington and various people are to those on this side of the Atlantic.
Was there a cost to signing it? In the lore of the U.S. Declaration of Independence, the thought was you're putting a target on your back. And, you know, John Hancock signed extra big to say, fine, come at me. Any dynamic like that here?
It's not like the death warrant of Charles I, where then there was a hunting down of all of those individuals. And I'm sure that did occur to the Founding Fathers in the 1770s, that that hadn't gone very well in the 1640s. But here, they tend mostly to be those who are actually on the king's side. So this is the group of the king's friends who are supporting the king in issuing something that is in theory, to be upheld by both the king and his council.
I mean, I think two people, in a way, should be saluted for the first really consensual edition, which is 1225, and they head the witness lists. And there's Stephen Langton, Archbishop of Canterbury, and Hubert de Burgh, who's the Justiciar of England, later Earl of Kent. And because the king is still underage, it's they who have crafted this consensual version. And they did one crucially important thing, which was to say in the actual text that in return for all these concessions, the whole realm has granted the king a tax. So there could be absolutely no suggestion now this is coercion. It's a freely entered bargain between king and kingdom. And that then is carried on in the confirmation of 1300. You know, that's still there. So I think Stephen Langton, Archbishop of Canterbury, probably for ideological reasons, believing in sort of consensual government, the rule of law, and Hubert de Burgh, perhaps for more practical reasons, they too played a very important part in the crafting of the consensual charter, and they are there in the witness list, showing it.
I mean, David's published on this as well. So the whole idea of the community, in the minds of the church, the community of the faithful, in the minds of those around Magna Carta, the community of the realm. And those twin concepts of trust and community, I think, are still of abiding significance to the way that society operates today.
I think we have a question from one of the Mississippians, is that right? One of our debaters later today, or you just happen to be standing near him?
Yes, I'm Devin Hutchins from Mississippi State. I wanted to ask, out of curiosity, I know you guys had mentioned that Pope Innocent had annulled the charter in either 1215 or 1216, soon after it was issued. But I wanted to ask, you guys stated that it was because of duress, but my interpretation was that the kingdom had been offered as a vassal to the Pope previously, and that the Pope was not so happy with the idea that the barons or the subjects of the king, the subjects of their vassal, were going around and imposing their own will as opposed to the will of the church. So I wanted to know if that was maybe a little bit off-kilter, or whether or not the duress point is more accurate.
That's part of it. So no sovereign power like the Pope is going to like a document that binds a sovereign power to do certain things. If you look around the world today, sovereigns, would-be kings often get on quite well with one another, perhaps sometimes better than they do with their realms. But in this particular instance, there's a very recent article by Dick Helmholtz that really nails down that it is the business of consent versus compulsion that lies behind the Pope's annulment. And the Pope makes it abundantly clear in the bull annulling the charter that it is the lack of consent, it's the fact that the king is compelled into it that lies behind the annulment.
And then that leads on to the fact that the Pope then accepts the charter. So Pope Innocent IV accepted the charter in the 1250s. But earlier than that, how was the charter saved? It was thanks to a papal legate, Guala, in 1216, 1217, with King John dead, and in a desperate situation in the middle of a civil war, who completely changes papal policy and accepts what John had rejected and issues with the underage king the first new version of Magna Carta. So in the end, precisely because it becomes a consensual document, the Pope actually changes tack and accepts it.
Yep.
Just a question related to that. The fact of the 1215 charter having that final clause, for if King John does not abide by the charter, that knights could go against him, take his property, and so forth. That, I understand, comes out of the later versions. And how much is that a significant factor as well in that later papal acceptance?
Absolutely fundamental. So that the so-called securities clause that empowers 25 barons to make war on the king, that's completely unacceptable to any sovereign. You cannot legalize rebellion in that way.
Yeah, so that does create another problem here, which is that, yes, that was left out. And if it hadn't been left out, the charter couldn't have become a consensual document. But on the other hand, that did raise the question of how can Magna Carta be enforced? And that's a question, of course, of very, very relevant today, which is all very well to have rules and law, but what happens if the ruler just ignores the rule of law? How can he be brought to book? And obviously you're facing that problem now. I mean, there were answers in 13th century England. The church had excommunicated everyone who broke the charter. You could bring writs to enforce the charter. So there were legal answers via which the charter could be enforced, perhaps not so very different from the legal remedies available in the United States today. But one would need to see how courts can give judgments. What happens if those judgments are ignored?
Well, which also reconnects to the observations earlier about the desirability of many copies that are true to the original and of public awareness, such that the ultimate arbiters is the public at large. I think I saw one more question here, and then we have to wrap up. And I'm also curious, maybe this can be by way of conclusion after that question. Are there any false notes in the melody of Magna Carta with the 700 to 800 year distance? There might be possibly things more or less relevant, but anything that would really grate if we were reincorporating it today?
New Hampshire tried to, a few years ago, insist that all new legislation should quote directly from Magna Carta. Magna Carta 1215. We will expel from the kingdom all
That was
foreigners.
our New Hampshire?
That's your New Hampshire. We will expel from the kingdom all foreigners. Well, that isn't necessarily. The interest...
Quite safe.
Yeah. We will, well, who have come to the injury of the realm, however defined, that we will, no interest will be charged on Jewish loans during the minority of a minor. That doesn't necessarily go down very well.
I love the necessarily caveat, but yes.
I think also, I mean, one of the, chapter 54 of the 1215 Charter does discriminate against women, and it puts women on a lower level from men when making an accusation of homicide, of murder. So that one is a chapter perhaps best laid on one side and forgotten.
Even New Hampshire might say no to that, yes. Question right here for our last
Being
question.
from New Hampshire, myself.
Good timing.
I apologize if you guys addressed this in the first 7 minutes. I was late coming in. But I'm curious about the immediate preservation in 1300. So when I think of a charter, I think they're delivered to, a monastery or whatever, and then they're kept locally, and the audience, the person who holds it is the person who benefits from it, and then it goes into whatever archives are needed. This is to the realm? This is to individual signatories? Do we know what happened, who was the recipient of any individual charter, and then what was done with it?
So we know that this was one of those sent to the sheriffs in 1300. We've got the publication schedule for the 1300 Magna Carta.
And how many fanned out, roughly?
We don't know, it's a guess, but there are 26 counties, and there are obviously other places that got one too. And it may have been, if you asked for one, you could have one as well. So maybe there were 30, 40 of these charters from 1300. And there was a constitutional crisis going on in 1300, so the king was trying to make war in France and Flanders and elsewhere. And there was effectively a baronial rebellion against which the king was reacting by issuing this document. And we think that the document that you've got here is the one that was sent to the English county of Westmoreland. We know that in the 1760s, the town of Appleby had an original 1300 Magna Carta that was shown to Blackstone but hasn't been seen since. And there is a direct connection there through the Clarksons and the Maynards to Appleby. So in all likelihood, this is one of those 30, 35 or so originals of 1300 that were sent out to be published. And that's also very important on this whole question of broadcasting and exhibition and remembrance of the Charter, that it had to be enacted publicly, it had to be publicly read, so nobody could say that they weren't aware of what was in it.
Charlie?
It was also put in the charter rolls and in the statute rolls as well.
For the first time in 1300, which is why not only do you get 2 witness lists for the price of 1 in your charter, but you have the best of all the charters that are going.
Well, it's extraordinary, the tales that you've been able to discern and elicit from this document, its sibling. And I know we are very much aware here of the weight of the document and the responsibilities of stewardship and the wonderful ways available to all of us to contemplate how something from truly so long ago carries forward a very distinct and bright thread about how to order our affairs and deal with problems as they come up, that there's never a real equilibrium time. And the price of freedom as eternal vigilance might be one of the things worth, if we're going to renovate Langdell, we should take out the chisel and possibly put that in place of, dare I say, green leaf or something on the building. Charlie, you're going to get the last word.
What you've also got on the priest of Langdell is non sub homine sed sub Deo et lege, not under man but under God and the law, which is not a quotation from Magna Carta but from Braxton.
Yeah. On that note, thank you all so much for coming today, and please thank our expert panel for their illumination.